Hello there and welcome again to the Employment Law Show. Good to have you back for another round over the next half hour. I can guarantee you one thing, you will learn a lot if you pay attention about workplace rights and employment law. That's why we do the show every week. John Scholes right here momentarily on your screen. My good pal and employment lawyer Lior Samfiru, always available to reach out to. There he is, 1-855-821-5900 to reach Lior and his team anytime. help@employmentlawyer.ca. Back it up with an email, always a good idea. We'll give you some more contact information throughout the half hour. We always have a main topic a little later on the show. This week it is 5 questions about mass layoffs and employee rights. What is that about? We'll drill down on that a little deeper. We'll get some phone calls from one of our radio shows, some emails. It's a whole mixed bag of busyness to get through, Lior, but we always start off with the case of the day, something you want to chat about. It's been happening over the last week or two. What do you got this week, pal? What's going on?
Hey, John. Great to be here, of course. Great to be talking about employment law and to try to demystify this very important topic. Man, I get so many questions, especially recently, I think with everything going on with our neighbors south of the border and tariffs. A lot of people's jobs have started being impacted, and a lot of other people want to understand their rights as to what will happen if their jobs are affected. Well, I'm here to answer questions, whether it's on the show, whether it's off the show. So by all means, if you want to know about employment rights, listen in for the next 30 minutes. You'll know what to do if you lost your job. You'll know what to do if you're going to be put on a temporary layoff, if your job is changed, your compensation is changed, if you're being mistreated, discriminated against, you name it, we cover these topics on every show, so you get the power back, so that you get the knowledge. And knowledge, of course, is power. And beyond the 30 minutes of the show, you can always reach me in the office by phone or email. We'll give you that contact information throughout the show. But this is such an important topic. If it's been important before, man, oh man, is it important right now? So let's start off with a call that I had recently and a discussion I had with an individual. Now, this person had worked for the same employer for about 6 years, never had an issue. He recently got into a bit of a confrontation with a coworker. During this confrontation, the person that called me said some inappropriate things, made some inappropriate comments. And as a result of that, the coworker went to HR and complained, said this person treated me badly. HR did the right thing. They investigated, they talked to everyone. And then the person that called me, my client, gets called into a meeting and they said, we figured out what happened here. We think you did something wrong. You treated this person inappropriately. And because of that, we're going to terminate you for cause. You're gone. Today's your last day. We're not going to pay you anything because we have cause, because we know what you did. So this person, of course, being very upset, lost his job after 6+ years, calls me and he wanted to know, is this right? Can they terminate me for cause? Now, here's the thing, John. This person did something wrong. I'm not making any excuses for him. He shouldn't have behaved the way that he did. He should have controlled his temper, not said certain things. It was wrong. But that's not the question. The question is whether that is enough to be cause. Is it enough to justify the ultimate penalty? And the answer is, no, it's not. It was one time, an isolated incident. And a one-time isolated incident is almost never going to be cause for termination. It's extremely difficult to terminate for cause. And doing something wrong does not equal being terminated for cause. Again, he did something wrong, no excuses. Okay, not suggesting otherwise. But that's not enough to be cause. There's other things the employer could have done. They could have given them a warning, a write-up, maybe even in some situation a short suspension, but not to terminate for cause. Therefore, this is a wrongful dismissal and he's owed full severance. For him, that could be as much as 9 months of pay. I want to remind everyone, employees and employers, that just because someone did something wrong, they messed up, they behaved inappropriately, does not mean they can be terminated for cause. It's extremely difficult. It's the worst penalty for the worst offenders.
Just to clear up, Lior, for the viewers, it doesn't mean that the employer cannot terminate him. Everyone would get the wrong, well, if he can't terminate for cause, I guess he's Teflon, you can't get rid of the guy. That's not true. They can let him go for that behavior, but it can be a without cause termination, yeah, which means more money.
Absolutely. They could have said, you know what, we just don't want this guy here anymore. We just want him gone. Absolutely, they can do that. They have to pay severance. With severance, they don't need cause. They can terminate just because they feel like it, but they have to pay full severance. Their mistake here, what made this a wrongful dismissal, is them saying we're going to terminate you for cause without severance. If they had paid severance, that would have been legal.
How many times, I mean, assuming that this person would have had some repeated behavior going forward, how many times would they have to have called him into the office and had a chat before they've, as you say, built up a case where they could let him go for cause, i.e. no money?
Well, obviously, that also depends to an extent on the type of misconduct.
Right.
You know, if you're late 3 minutes, that's different than if you're calling names and using profanity to a coworker. Those are different offenses. So some offenses may require more chances than others. But as a general rule of thumb, I would say 3 situations, 3 warnings are justified before you terminate for cause. So we give you a warning, we're giving you another warning. Hey, this is your final chance now or else. That's how you do it. Now, in some cases, you will need more. In some cases, you can do less. But to jump from nothing to a termination for cause is going to be almost always illegal.
Do you always recommend that somebody in this situation goes to HR? Because a lot of folks are thinking, you know, what happens if HR does an investigation and it found out, you know, they came to a different conclusion than I look bad, I might get fired for that. So I'm not going to go to HR. I'm going to keep it tucked in, right?
So if we look at it then from the perspective of the person that has been mistreated, then yeah, absolutely. If you've been mistreated, you should talk to HR or whoever the right person is in your workplace. Let them know. And by the way, in writing, even if you speak to a HR person, make sure you follow up with an email so there's no doubt. You cannot be punished for doing that regardless of the outcome. And by going to HR, you trigger their obligation to deal with workplace harassment or a poison work environment. They have to do it by law, but they can't do it unless you tell them about it.
All right, let's keep this rolling, pal. Employmentlawyer.ca. Go there anytime as well. You want to find a radio station in your community that will probably carry our show. You can listen online as well and on the AM dial, of course. But we get a lot of phone calls every week on our radio shows. People want to know stuff, so we tell them. And sometimes we cherry pick a few. We play them back here, and so we can all learn from them, right, Lior? Our first phone call for this show is coming up right now. Listen up.
My husband was just let go. He's been with the company for 3 years. He was let go without cause. There was a company restructure. That was their reasoning. He was offered 3 weeks of pay in lieu of notice, as well as 3 weeks salary continuance in the event he signs the termination document. So he's offered 6 weeks total. Just wanted to see if he's entitled to more.
How old is your husband? What kind of a job was he doing?
He was in IT, and he's 34 years old.
There you go. You got some details. What do you think?
So common situation, someone's called in, something, restructuring, cost cutting, we're letting you go. Remember what I said before, that is legal, but severance has to be paid. Now, this person received 6 weeks of total pay after 3 years. That's 2 weeks per year of service. Most people would say, well, that sounds right, 2 weeks per year of service. It's not right. In fact, it's a wrongful dismissal because he's owed more than 6 weeks. How do you know what he's owed, what you're owed if you're in that situation? Very simple. You can use the severance calculator. We're going to do that right now. We're going to go to pocketemploymentlawyer.ca, plug in the information, and let's see what the right amount of severance is for this person. So we know that he's been there for 3 years in an IT role. He's 34 years old. 6 weeks is what he's been offered. We see there, by the way, very conservatively, that he's owed 3 months pay. In fact, I would say it's probably even 4 to 5 months. But even 3 months, that's double, more than double what he was offered. So that's why we use the severance calculator. Whether you worked for it for 3 years, 3 months, 30 years, doesn't matter. You can go to pocketemploymentlawyer.ca, use the severance calculator. It's free and anonymous. And man, will you be glad that you did.
All right, phone call number 1 down, Lior. Good stuff. Let's go to phone call number 2. Here it comes.
I was planning on returning to work after mat leave and received an update from my employer that they had added some additional responsibilities to my job title. I had then asked if I would be getting a raise for those additional responsibilities, and they said no. I just want to know if that's legal, if I can fight back in any way.
What do you think?
Yeah, so the rule with maternity leave, parental leave, is that you have to be taken back to the same job at the same terms that you had before the leaves. There's very little wiggle room here. Same job. So if in this case she's brought back to a different role or different responsibilities, that's potentially a violation of the obligation under the Employment Standards Act, which say same job. Beyond that, even if we forget about that, if this job is now very different, that could be a constructive dismissal. Your employer doesn't have a right to just change your job in any way that it wants at any time that it wants. So there's those aspects here, potentially human rights violation, potentially employment standards violation, and potentially constructive dismissal. So I would tell her to call me, but remember as well, coming back from a parental leave, same job, same pay, same hours, same everything. If that's not what happens to you, that could be illegal. You may have some significant entitlements, and you need to call me.
I want to drill down for a sec, Lior, on the whole parental leave. We talk about how important that is. So, you know, across this country, compared to our friends south of the border, we got really generous parental leave opportunities there for people. I know in Ontario it's up to 18 months. So I can't imagine an employer is going to leave an empty desk for 18 months. They got a business to run, so they may get someone to cover off your mat leave. Well, they look 18 months down the road and the person who was filling is an absolute rock star. We don't want to get rid of them. We like the person coming back. They're good too, but this person was really efficient. Can I keep them, or do I have to shove off with that employee and come back to the original like coming off a mat leave? How does that work?
Well, you have to bring back the employee on leave to the same position. That doesn't mean you have to let go of the replacement. If you can keep both and find work for both, then that's fine. But if the choice is either bring back the person from leave or keep the employee that's been replacing them, you have to bring back the employee from leave. There's no debate there. There's really no wiggle room there. If an employer can make it work so they're both there, fantastic. Otherwise, that employee on leave has a statutorily protected job. Means by statute, their job is protected. So the employer cannot take away that protection by saying, hey, we like Joanne more than we like Barbara, so we're going to keep Joanne. Doesn't work that way. You have to bring back the employee from leave. And again, if that's not what your employer is doing, that could be illegal. That could be a violation of a couple of statutes. You really need to give me a call.
All right, we'll take a short pause, Lior, and give you a chance to take a breath as well. We'll get to our third phone call on the other side, and our main topic, 5 things to know about mass layoffs. That's coming up as well as we continue the employment law show. Stick with us. We're coming right back. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Employment Law Show. Lior Samfiru right beside me. My name's John Scholes. I simply host the show, and you want to reach out to Lior if you have any issues. Got a great team with him. Always ready for that phone call, 1-855-821-5900. Back that up with an email, help@employmentlawyer.ca. We mentioned the phone calls to Lior across the country, our radio shows in various markets. You can find out where to catch one near you at employmentlawyer.ca, the media tab, and our phone call, third one of this show is coming up right now, Lior. So let's listen in.
Was recently let go, and there's a non-compete clause in the release that I'm asked to sign. Totally appreciate not competing against the company's existing or past clientele, but I provide a pretty specific service for a specific industry, and wondering how enforceable it is to keep me from earning a living doing the thing that I'm good at doing.
Are you in an executive or senior management role?
No.
Yeah, that whole landscape has changed, hasn't it, recently with the non-competes?
Absolutely, it's changed. But before I even talk about that, let me talk about another issue here. Is the first question that I would expect someone like that would ask me is, I was let go. Let's talk about what I'm owed. So this person is actually asking me, well, I'm not even asking you about what they owe me. I'm asking about this non-compete. Well, why is that a problem? The problem is that he's probably and very likely owed a heck of a lot more than what he's been offered. Maybe he was offered 3 months pay and it should have been 18 months pay. I see this all the time. So whenever you're let go, the first thing you should focus on is not your record of employment and not whether you received your accrued vacation pay. It's not whether or not you have to sign a non-compete. The first question is, am I getting what I'm owed? That's what you call me for, or you use the severance calculator at pocketemploymentlawyer.ca. That's the first thing you concern yourself with. But now let's address the second issue, which is this non-compete. It's not appropriate to include a non-compete in a termination letter. So essentially this employer is saying, for us to comply with our legal obligation, you have to agree not to work for a competitor. Otherwise, we're not going to comply with our obligations. Nonsense. You can't do that. Your employer has to comply with its obligations to pay severance, and they cannot impose conditions like a non-compete in order to do so. Beyond that, to what you've alluded, John, for most people now, a non-compete is not enforceable. Whether it's by statute or operation of common law, it's not enforceable. So it's certainly not appropriate to require that. Don't sign a non-compete as part of a termination letter ever. Give me a call. Let's talk about that. Let's make sure you're not agreeing to something that could be problematic later. But of course, coming back to my original point, always, if you're let go, the first thing you should focus on is, what is my severance? Am I getting what I'm owed?
And with that, we move on to our main topic. It's always an important part of the show, Lior, and this week it is 5 questions about mass layoffs and employee rights. Question number 1 for you, my friend, is what is a mass layoff versus a typical layoff that we all know about?
So whenever we're talking about a mass layoff, and that could be defined terms under the Employment Standards Act, but generally speaking, without getting technical, a mass layoff is when a large group of people are being let go, as opposed to a regular layoff or regular termination when it's usually 1 or 2 people. So mass layoff refers to when large groups of people are let go. And we've been seeing that a lot recently with companies. Maybe it's because of what's happening in the US and the political climate where, instead of employers letting go 1, 2, or 3 people, they're letting go 20 or 30 or 50 people or more. So we need to understand what this means, and does it change entitlements? Because it's easy to fall into the trap and think that, wait a second, company's struggling, they're letting go of a lot of people. Maybe that impacts my entitlements. Maybe I don't get what I'm owed. So we want to really make sure that everyone understands what to do, what it means if you're part of a big group of people that have just lost their job.
Yeah, that point you just made is interesting, Lior, because it makes you think, okay, in that regard, if it's a mass layoff and everyone's getting, turfed out in one foul swoop, does that mean the severance package is the same for everybody? To make it simple, I guess, for the employer, can they do that? Or it still doesn't make a difference if it's 1 or 100 people?
At the end of the day, your full termination entitlements are an individual thing. They are an individual thing. So it's based on your age, your position, your length of employment. So no, your full entitlements are not going to be impacted by the fact that it's a group termination, are not going to be impacted by what other people get. Now, I've seen many companies that are letting people go in a mass situation or in a group situation, giving them all the same severance. Well, that's not correct, because if you've been there for 20 years and are 65 years old, that's different than the person that's been there for 3 years and they're 35 years old. Okay, you can have very different entitlements. So don't fall into that trap. If you're let go, it doesn't matter how many people have been let go with you. You have entitlements that are significant, and even in that situation, there's still the same 90% chance, 90% that you've been offered less than what you're actually owed, irrespective of what your colleagues get, irrespective of what the company says you should be getting. Make sure you call me, make sure we go through that analysis. You'll be surprised by how much you're actually legally owed.
So if we were to put on our employer hat for a moment here, Lior, and think, well, Lior, I'm not letting 1 or 2 people go, I'm letting 50 people go. So do I get some sort of discount on how much severance I got to pay? Does that affect it from an employer side?
Yeah, terminate 50, pay for 40, right? We have a special today. No, it doesn't work that way. You still have to pay the individuals what they're owed. Now, if you're a smart employer and you have proper employment agreements in place, you could significantly limit your entitlements. For a company that's terminating a bunch of people, that could be millions and millions of dollars in savings. But that's only if you have all those employees sign proper employment agreements. Otherwise, you have to go through the analysis individually, look at a person's age, their position, their length of employment, the availability of similar employment, and then assess. Now, there's another point, John, that I want to make here, and that is if you're part of a mass termination, that means that potentially the industry that you're working in is one that's struggling right now. It's one where maybe there's not a lot of jobs. And now there's going to be more people looking for jobs because a bunch of people just lost their job. So that means it's going to be harder to find another job, new employment. That means you get even more severance. In situations where it's difficult to find new jobs, that means you get even more severance than you would otherwise get. So, man, that's another reason why you must call me if you're let go always, and certainly if you're part of a larger group.
So another question, Lior, just based on the numbers, if I'm an employer, can I apply a little more pressure to employees to accept that offer quickly? Because, you know, Chuck just signed this, I got 50 people at my door, I got to do the same thing. So if you could just throw John Hancock on that, and out you go. But, you know, they can't do that, can they?
Well, employers would love that, right? We have 50 people, 100 people who let go. We just want them all to sign because we don't have the time to deal with them individually. Yep. Well, too bad, right? Law is law. You still have to deal with them individually. The person's legal rights don't expire on the employer's deadline. Individuals still have the same 2 full years to pursue their legal entitlements. So no, that pressure tactic, that deadline, you better accept this by Friday or Tuesday or whatever it is. It's all it is. It's a pressure tactic. It doesn't mean anything. Don't stress out over it. Every week I get calls by people that are very concerned and upset about that pressure tactic, that deadline. Don't worry about it. Your legal rights won't expire. Make sure you get proper advice, because if you don't, you're extremely likely to accept less than what you're owed.
Let me ask you this final question, though, Lior. So if you're going to be let go and you know it's coming, you're part of a mass layoff, could be 10 people, could be 110 people, can you still get individual legal advice from you? Because I know a lot of people think, oh, it's kind of like class action territory. We're all going to go to one guy and have this thing sorted, or it should be individual, yeah?
It is an individual thing, yeah. In terms of severance, no, class action is not really a factor, and you don't want that. Class actions are a lot tougher, longer to resolve. You don't want that. It's an individual thing. So yeah, I oftentimes represent 30 people from the same company, but they're individuals. I represent them each individually and negotiate and resolve their case individually. So if you lost your job, it doesn't matter what your friend Bob or Harry did, call me. Let's make sure you understand what you're owed and make sure you get what you're owed.
Okay, with that, we'll take a short break, Lior. We'll go to another website, which is free and anonymous for you to use to ask your questions. They may appear on a future show called terminationquestions.com. That is where we are headed after the short break. As we continue more of the Employment Law Show, stick with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. Lior Samfiru right there. Reach out to him anytime. This number and the email are always on your screen. We'll give you that before we leave this particular half hour. But terminationquestions.com, Lior, that is where the question is coming from now. You can use it. It's free and anonymous. I was told today that my job is being terminated without cause due to downsizing. I've worked as an operations manager for a large organization for the past 13 years. I make about $80,000 per year. I'm 68 years old. In initial conversation with HR, it seems I will be offered a week per year of service. Should I get more? What do you think?
Well, another myth, right? the week per year of service. A lot of people have asked it, say, well, that might not be great, but it's legal, right? A week per year of service, that's kind of what you should be getting. Nonsense. Let's be very clear. If there's one thing in 10 years or 15 years, however long I've done this show, that I want everyone to remember, please, there's no rule of a week per year or 2 weeks per year. Nonsense. You get significantly more. So let's now find out how much this person is actually owed. For that, we're going to go one more time to the severance calculator, because I really want you to see how it works. We're going to go to pocketemploymentlawyer.ca, use the severance calculator, and let's see what the right amount is. Middle manager, been there for 13 years, age of 68. Company says a week per year, that's 13 weeks. Nonsense. You see that this person is owed right around 20 months, 18 to 20 months of pay. So it's more than a month per year for him. Forget about a week per year. So that's why we go to the severance calculator. Again, free and anonymous. Even if you're just curious and you want to be prepared, that's where you go to pocketemploymentlawyer.ca.
All right, good stuff, Lior. We're going to bounce over to a question from your live stream. By the way, Lior and the other lawyers host it during the week. You can catch it Facebook, YouTube, LinkedIn. The address is at stlawyers.ca. My company is being taken over, and everyone in my department has been offered new employment contracts. The contracts don't recognize any of our previous work. If we don't sign, are we owed any severance?
Yeah, and this happens often. If you're working for a company, the company's sold, the new company comes in. If what they're offering you is a bad deal, and if they don't recognize past service, you're taking a big risk. Because here's what happens. You start working for the company, they let you go 6 months later. They say, oh, you're a 6-month employee, we're going to pay you for severance for 6 months. But you could have worked for the other company for 15 years. So in most cases, you may be able to reject this offer of employment because of that and get your full severance now. Now, of course, the devil's in the details, and this thing can get tricky. So I don't want you to reject the offer. I don't want you to do anything without speaking to me first, okay? In a sale of a business, you want that service to be recognized, because later on, if they're letting you go, you'd get full severance for all the time, even with the previous company. Don't accept that offer. Don't reject that offer without speaking to me first. It can be very, very important.
Okay, Lior, you know we wrap up every show with employment law rapid fire. We'll get to that right now. Strap in. Here we go. Question 1. Can an employee be placed on an unpaid suspension? Unpaid.
For most people, the answer is no. Non-union employees, your employer does not have a right to put you on an unpaid suspension. That could be a constructive dismissal. A paid suspension in some situations is appropriate. Unpaid suspension, not so.
Rapid fire number 2. Can an employee be monitored or put under surveillance in the workplace?
The answer generally is yes. You do not usually have an expectation of privacy in the workplace unless you're in a changing room, bathroom, something like that. Otherwise, your employer can monitor you. They're not allowed to audio record you without your knowledge. But other than that, yes, they can, of course, monitor you.
Get to question number 3 on the rapid fire section to wrap up the show, Lior. Can an employee be denied a vacation request? What?
Not nice, not fair. A lot of employees are going to be unhappy, but the answer generally is yes. Your employer is not required to approve a vacation request, and beyond that, they're even allowed to decide when you take the vacation, to schedule it for you. Now, employers don't do that usually because that's going to create unhappy employees, but legally speaking, the employer gets to decide if and when you take vacation, and they can approve or deny a request.
Rapid fire question, next one coming up here. Can an employee be penalized for refusing unsafe work?
Absolutely not. You have the right to refuse unsafe work. You should refuse unsafe work, and you're protected by law in that situation. If anything happens to you when you refuse unsafe work, call me.
The old contract question to wrap up the rapid fire section and the show this week. Can an employee be let go before the end of their contract?
Well, if you signed a contract for a specific period of time, 6 months, a year, 2 years, yes, you can be let go before, but your employer in most cases has to pay you for the balance of the contract. If it's 2 years, it's 2 years. If it's 10, then it's 10. So remember, the balance of the contract would have to be paid.
And that is it for the Rapid Fire. Another show we'll talk about why bother offering contracts like that in the first place. But that's next week, maybe. In the meantime, reach out to Lior. The phone number, 1-855-821-5900, help@employmentlawyer.ca. And for all other matters, pocketemploymentlawyer.ca. We'll catch you next time. Thanks for joining us right here on the Employment Law Show.